Good afternoon, everyone. I'm April Frazier Kamara, and I'm very excited to welcome you to the first part of a series hosted by the American Bar Association Criminal Justice Section. Our goal in hosting these monthly discussions is to have a forum to tackle the most pressing issues in criminal justice. As many of you know, our world is facing some of the most pressing challenges that I have personally seen in my lifetime. And I feel confident and I feel very strongly about the role that the American Bar Association should be playing in tackling these very pressing issues. So today, as we come together to host a first conversation, I had prepared remarks to honor Justice Ruth Bader Ginsburg. And hours before going live, I heard of the news of the non-indictment of the police officers who killed Breonna Taylor. So in the spirit of Ruth Bader Ginsburg, I'm gonna start first with a tribute to Breonna Taylor. And I am going to remind people as we talk about these issues today that Breonna Taylor was a real human person. She was a daughter. She was a friend. She was a sister. And most importantly for me, she was a Black woman who has not received justice. So on today, as we talk about the issues of the rule of law, race, and policing, we have to be reminded that we're talking about real human lives. So I want to be very clear that my role as being an African-American woman sitting in this seat as chair of the American Bar Association is to constantly remind us that we can do much better than what we're doing right now in the criminal legal system. So as we engage around these issues today, I want you to think critically about what your role is, whether you're a judge, a prosecutor, or another advocate within the system. What can you do to produce change in the system? So in honoring the legacy of Ruth Bader Ginsburg, I encourage you to be bold, be courageous, have the audacity to believe that we can in fact change this system, because change must happen. And it is beyond time for us to reimagine what justice looks like for every person in America, not just some of us. So today, I am very happy to welcome experts to join me in a conversation around these important topics. Professor Angela Davis is a professor of law at American University and a leading expert around the issue of race, but also the issues of race and prosecution and prosecutorial discretion. And so I'm very excited to have her joining us today. We'll also hear from another amazing legal attorney and advocate, Kelly Henry, who is a federal public defender in Nashville, Tennessee, and has decades long of experience fighting within the death penalty world, specifically advocating on behalf of people who are facing the most severe punishment in the criminal legal system, which is death. And so as we talk about the issues today, as we honor the legacy of Ruth Bader Ginsburg, as we pause and remember the life of Breonna Taylor and many other people who have suffered injustices in our legal system, I would ask you today to tune in with an ear of action-oriented next steps, and for us to have a serious conversation about how we can produce change within the criminal legal system. So Professor Davis, I originally was going to start out with a conversation about the rule of law and the passing of Justice Ginsburg. But like many people, and hopefully not just African Americans, but my heart is very heavy today because unfortunately the system has reminded me that there are two worlds of justice and we live in two very stark realities. So can you start us out by talking about Breonna Taylor and how do we continue to see dispirited treatment of people based on the issue of race, and what type of system do we have that produces, quote, this type of justice?
Well, thank you for having me, April. And I have to say, I'm having a hard time today because of what happened a couple of hours ago, but it never, I mean, I'm 65 years old, but I don't ever get used to this. I don't get used to the fact that we have a criminal legal system that simply does not work for Black and brown people. It simply does not. Our criminal justice system is in a state of crisis, and it has been for a very, very long time, for a lot of different reasons. You know, first of all, we've got over 2 million people in prisons and jails. We got over 7 million people under criminal justice control, and people of color constitute a disproportionate number of those people, right? They are more likely, Black and brown people are more likely than white people to be arrested, even engaging in the same behavior. Once they're arrested, they're more likely to be convicted. Once they're convicted, they're more likely to get stiff sentences. African-American men are 6 times more likely to be incarcerated than white men, and 2.5 times more likely than Latino men. Black and brown people are treated worse than their similarly situated white counterparts at every step of the process, from arrest through sentencing. And that is true whether they are accused of a crime or whether they are victims of crimes. Breonna Taylor was the victim of a crime, but her life meant nothing. Today, we have evidence of that. And there are a lot of causes for this disparate treatment of Black and brown people. But one very big cause is the discretionary decision-making by criminal justice officials, namely law enforcement, namely police and prosecutors. And so I just want to spend my few minutes talking about the role that police and prosecutors play in creating these unwarranted racial disparities and unfair treatment of Black and brown people in this criminal legal system. And we know that police have a lot of power, right? That they have a lot of discretion on the street when they stop and search people and arrest people. But when they stop and search and arrest people, not based on reasonable suspicion or probable cause, but based on the color of their skin, they engage in racial profiling. And that is a leading cause of the unwarranted racial disparities in our criminal justice system. And that racial profiling often leads to death. It often leads to the unnecessary use of excessive force. We have so many examples of that. Black and brown people have been killed, unarmed Black and brown men and women have been killed by police officers from the time of slavery up till today. It just has gotten recent attention because of cell phone cameras and social media, but it has happened since the time of slavery, and it persists. Everyone thought it was going to stop after George Floyd, and it continued after that. And police officers are not held accountable, right? So they racially profile, and that behavior contributes to the racial disparities we have in our criminal justice system and the numbers I just mentioned, right? But they also are not held accountable when they engage in crimes, right? So Black people can't get justice on either end. But then there are prosecutors, right? Police officers have a lot of power and discretion, but they only have the power to bring the person to the courthouse door if the person lives, if they make it that far. They have the power to bring them to the courthouse door. It is the prosecutor who decides whether the person stays in that system, whether they're going to be charged, what they're going to be charged with. And that power, the charging power and the plea bargaining power, prosecutors control that, and those two powers allow them to control this system. Just because there's probable cause to believe that someone has committed a crime doesn't mean the prosecutor has to charge. And so when they make charging decisions, one person might get a break and another person who engaged in the same behavior will get charged. And far too often, those decisions, those disparities break down along race and class lines in our criminal justice system. The statistics show it overwhelmingly. Similarly with plea bargaining, right? When you take into account that 95 to 98% of all cases are resolved by way of a guilty plea, prosecutors, in essence, control the system. And it's very easy, by the way, to charge an individual. The standard is probable cause, more probable than not. They charge people every single day, except when it's a police officer, and then the script is flipped. I was just listening to the Attorney General of Kentucky stand before the cameras and talk about how the grand jury is so independent and prosecutors have nothing to do with those decisions. And every person watching this webinar who is a prosecutor or a defense attorney knows that prosecutors control the grand jury. They indict people every day. They indict Black and brown people every day on the scantest of evidence. But when it comes to police officers, somehow the script is flipped. So that's why I say this system does not work for Black and brown people. We are not treated fairly, whether we are charged with crimes, suspected of crimes, or victims of crimes. We are treated worse than our similarly situated white counterparts all the time. And it is continuing and it is persistent. And that's why I hope that we can talk about what we can do about this. We need to pay attention to district attorney races, because these cops are not being held accountable, and prosecutors have all of this power, and the decisions that they make help create these disparities. I'm not sitting here saying that prosecutors intentionally go out and choose and decide that they want to lock up Black people. There are a lot of reasons for it, right? There's this thing called implicit bias that we all suffer from, right? That makes them look at a Black or brown kid and see a criminal, and look at a white kid who did the same thing and decide that they deserve a break. But the fact that it's unintentional doesn't mean it's right, and doesn't mean it's fair, and it needs to stop. Prosecutors need to hold cops accountable when they break the law, and it is not happening. It has not happened. It has never happened. But that can change. I don't want people to feel hopeless, and I hope I'm coming near the end of my time here, but I hope that we will be able to spend some time talking about what we can do to change this awfully unfair system, criminal legal system that we have in the United States, because there's something we can do, and I hope we can talk about that. So I'll stop there.
Thank you. Thank you so much, Professor Davis, because I do think for many people who have worked within the system, while my heart is heavy, I'm not surprised, right? If you have worked within the criminal legal system, you see the injustices every day. And you would hope that when you get national attention, that the system in some way could model new or better behavior. But I do think that we have a moment in history where 80% of America has come to recognize that the criminal legal system has a problem, and it is broken, and it is rooted in race. And I'm hopeful that these conversations are going to move people to act, not just be aware. And so, Kelly, I'm going to turn to you to talk about all of these statistics and these decision points, and all of the highlights that Professor Angela Davis just spoke about are literally textbook examples of the case that you are fighting for right now to save the life of Purvis Payne. So can you talk to us a little bit about how the issue of race has played out in this particular case and continues to be at the center of the fight against his execution?
Yes, thank you. I appreciate the opportunity to be here on this very sad day. It is my privilege to be Purvis Payne's attorney. It is with the same heavy heart that I can say what we saw today with the non-indictment in the Breonna Taylor case. Another example of what we know about with the death penalty, which is when it comes to the death penalty, Black lives don't matter. When it comes to the death penalty, the race of the victim has more of an indication of who actually gets executed, who actually gets charged, than any other factor. Recently, there was a study by the Death Penalty Information Center, which documented what those of us who do this work already know. 85% of the individuals on death row who are ultimately executed had a white victim. In Texas, a recent study showed that a Black man is 3 times more likely to be executed if his victim was a white woman. Purvis Payne was a 20-year-old kid on June 27th, 1987. The son of a preacher and a child care worker. He was known for his broad grin, his playfulness, his helpfulness around the church. He came from a good, solid family. And on a summer day, he was doing what 20-year-old kids did on a summer day. He was hanging out with his friends, drinking a little beer, no doubt. But that's all he was doing. He went to visit his girlfriend. And she was supposed to be home. This is 1987. We didn't have cell phones back then. So the way you found out somebody was home was you went and knocked on the door. She wasn't home, but across the hall, he heard the muffled sounds of Sharice Christopher. And when he walked into her apartment, he saw a scene that would overcome any of us. And that was Miss Christopher and her daughter and son had been brutally stabbed. Her daughter was already gone, and Miss Christopher was clinging to life. Purvis bent down, tried to help her, and then he was overcome with panic because he realized he was Black, and this was Millington, Tennessee, Shelby County, a county that has the worst history of lynchings in our country's history. He knew that he would be seen as a suspect. And so he did what any 20-year-old kid would do. He ran, he panicked. And he was immediately seen as a suspect. His worst nightmares came true. But the problem is that the police officers who were involved in this investigation brought their bias to the investigation. They didn't consider any other alternatives except that Purvis must be guilty. And so what they proceeded to do was destroy any evidence that could be used to exonerate him and frame a narrative based on racial stereotypes. This was a young man who was intellectually disabled, whose parents came to the police station, whose mother said, if you think my son did this, test him for drugs, because there's no way my kid would do this unless he was on drugs. So test him right now. And they didn't do it. And every one of you watching this is involved in the criminal legal system, and you know that if a police officer thinks that their suspect is on drugs, they're going to test because they want that evidence at trial. But they didn't here because they knew he wasn't on drugs. But that evidence was lost forever to Purvis and his family. And then his family and he charted a course through the criminal legal system that marginalized and ignored them, that refused to consider evidence that would suggest he was innocent. This is a crime that would not be committed by somebody like Purvis Payne. He was a gentle, fun-loving kid. He helped his dad paint houses. He didn't have a history of violence before, and he hasn't had a history of violence since. His behavior in prison is pristine. The prosecutor admitted in post-conviction that it didn't make sense that he would do this. He couldn't figure out the motive until 2 weeks before trial, when they tested a tiny little piece of white paper, and the TBI lab came back and said there were traces of cocaine on that paper. Now, field tests said there were no drugs on that paper. But suddenly, somehow, 2 weeks before trial, we have traces of cocaine. And that meant that he was somehow this cocaine addict who was hyped up on drugs, and that must be why he did it. And, he must have been wanting sex because, he looked at a Playboy that day, right? All of the narratives of the drug-crazed super predator that have followed African-American men throughout history and unfortunately follow them to this day. They didn't, by the way, investigate the fact that the victim had methamphetamine in her system. They said, oh, well, that must have just been, she was on diet pills. She was a young white woman, so she must have just been taking diet pills. They didn't investigate the fact that she had involvement with drug dealers in the area. They didn't investigate her ex-husband, who had a brother serving time on death row in Florida for 2 murders, whose other brother was so violent that their mother shot him. The ex-husband himself was violent and had a history of abuse towards her. He allegedly had an alibi by being in the local penal farm except anybody who knew anything about that penal farm knew that you could be picked up on the side of the road and be gone during the day. As long as you were back for count at night, no harm, no foul. So it was the perfect alibi. But now, last week, we had a great win. We won DNA testing through the help of the Innocence Project, who came involved in the case just a few short months ago. Problem is, when it came time for the hearing, some of the most important evidence has gone missing. The victim's fingernail scrapings are gone. Her clothing, gone. Vaginal swabs, gone. Anything that would be terribly probative, gone. But we still have evidence. We still have evidence and we still have hope. Testing is underway as we speak. April talked about, this is a time to be bold. And, last week we had a great win, and then Justice Ginsburg passed, and then we have the non-indictment of Breonna Taylor, and it's hard to not want to, just climb into bed and give up hope again. But we are going to be bold on behalf of Purvis Payne. He is an example of the criminal legal system at its worst, but unfortunately, he is an example of something that happens all too often. In Tennessee, we have 51 men on death row. 26 are African American, and 23 of those African Americans are from Shelby County. In the last 10 years, Tennessee has only sentenced 6 men to death. 5 of them have been Black. So it's not getting better in Tennessee. And the challenge is to those of us who are white to face our implicit bias, because it is well-meaning white people who have failed Purvis Payne as much as Black people. Well-meaning liberal white people who didn't understand, who still don't understand, who have to be open to learning about our own biases, because we can't overcome them, and we can't make bold moves, and we can't speak truth to power until we come to grips with how we contribute to the injustice of Black people in this country. For me right now, that means seeking justice for Purvis Payne. He has an execution date of December the 3rd. And the thing is, he shouldn't even be on death row because he's intellectually disabled. And that's what brings us back to Justice Ginsburg. Justice Ginsburg in Moore versus Texas said, states shall not execute people with intellectual disability. And yet the state of Tennessee just says, well, can't prove it. You don't have a procedure. So you might actually be intellectually disabled, but we're not going to let you adjudicate the fact that you're intellectually disabled. And that's how we'll execute you, even though it violates the Constitution. So we're on a campaign to do justice for Purvis and his family. His family, again, his sister, Yolanda, who knows April, is one of the most remarkable human beings I think I've ever met, that she continues to have joy and hope in what is really a very dark time, that she and her family have stood by Purvis for these 33 years. They have been in prison with him. They have walked this journey with him every step of the way. They are a good family. They deserve justice. So I urge any of you who are watching to please go to purvispayne.org, offer help, lift up your voice, tell his story, speak his name, talk about him on social media, because we have a chance to do justice by this man and his family. There is a chance to save a life before December 3rd. Thank you.
Thank you. Thank you, Kelly. I think it's so important, and many of you may have already heard about the story of Purvis Payne in my column as chair of the ABA. We have to remember that as we talk about these issues, and while it's an honor to sit in spaces and sit around policy tables to talk about race and the rule of law and the integrity of the system, we have to remember every single day that there are lives on the line. And I think the case of Purvis Payne embodies everything that is wrong with our criminal legal system. So I would urge you all to learn more about his case at purvispayne.org. But Patrice, I want us to pull up a poll because Kelly, she mentioned a very important as she talked about Justice Ginsburg and the role of the court and the integrity of the rule of law. So I want to pose a question to our audience before I turn to Professor Steinhardt to talk about the threats to, it's interesting because when we talk about the integrity of the rule of law, I don't know, for me as a Black woman, I have not had a whole lot of faith in the system. So as people talk about this issue, I think Professor Steinhardt will be able to frame it from the standpoint of understanding the fragilities that were already existing for many communities of color. But right now, as we face the rapid replacement of Ruth Bader Ginsburg on the US Supreme Court, we want to poll our audience today and ask people, how many people are concerned? Patrice, if you could start the polling question. How many people are concerned about the integrity of the US Supreme Court? And we can give people just about 15 seconds to answer, but if our audience, if you could weigh in. Okay, great, wow. 96%. So, Professor Steinhardt, who's a professor of law at George Washington University, can you talk to us today a little bit about where we are right now and the very real threats that we face right now concerning upholding, I would refer to as the theory around the rule of law?
Well, first of all, let me say I'm awfully sorry that my technology is not working. It's just one more thing in 2020. It is an honor, obviously, to be invited to participate in this webinar, especially with you, April, and with these panelists. So thank you all for the opportunity to raise one person's voice in confronting the true meaning of the rule of law ideal in this country at this time. This is a day of anger and heartbreak, but it also seems to me a day of resolve, something that connects the frightful news about the non-prosecution in Breonna Taylor's case with the frightful death of Ruth Bader Ginsburg, is that we get to feel the full range of what the rule of law ideal is not, and could be. I mean, all you can think at the moment, I think, is that the rule of law is a cruel hoax, that it doesn't mean anything, that it hides power, and in particular hides white supremacy, and it has done that from the beginning of this country. But it may be the best route forward. That is, when I think about Ruth Bader Ginsburg, I think that she looked at the rule of law as both an obstacle and as a promise. She was able to look at the language of the 14th Amendment and imagine the ways that the rule of law that was actually baked into the 14th Amendment might be used to assure the rights of women and LGBTQ plus people. That might seem obvious to us now, but I don't think it was obvious when she thought of it. And you know, here she was making her first argument in Reed versus Reed, making it clear that the 14th Amendment was not limited, but could be used in new ways, even jazz-like ways. I know she was an opera aficionado, but I have a secret fantasy that she had a secret stash of Coltrane and Tyner, Davis and Bill Evans, and that she understood the power of improvisation within the law, that you would be true to the music in the process of creativity. And so really the dominant set of ideas, I think, that holds this panel together is that the history of the law and the history of racism in the United States, especially white supremacy, are intimately connected. And I think RBG's, the arc of her life as a litigator and as a jurist demonstrates that even neutral principles or idealizations like the rule of law mask power, specifically power in the form of racism, racial inequality, white privilege. There's a bumper sticker version of I support the rule of law. It's a little bit like support your local fireman. But once you come off of the bumper sticker version of the rule of law and understand that the apparent neutrality in principle of things like equal protection or freedom of speech or the rights of private property have been characteristically compromised, not occasionally, characteristically compromised in application in ways that disadvantage people of color, so that this exhausting disconnect between the orthodoxy that race ought to be or is irrelevant in the law and the historical reality that the law has been this dominant vehicle for enforcing white supremacy seems to me an abstract matter, but also a deeply pragmatic matter. And so, you know, I think that it's possible for white lawyers like me to think about a sort of a highlight reel of famously racist decisions by American courts in the past, obviously Dred Scott or Plessy or Korematsu. And I'm very aware that in some communities, the fact that those decisions have been overturned or repudiated has been overinterpreted to mean that somehow we're making meaningful progress. And it seems to me that confronting racism in those more obvious forms prevents us from tracking out, if you will, the legal component of continuing forms of white supremacy, including differences in income, health, education, housing, employment, access to credit, imprisonment, police practices, political representation, military service, it goes on, and we're just talking about a tip of that iceberg. But I guess I would close with one, well, it's a point where I find some hope, frankly, but not a lot of resilience at the moment. But I think it is about Ruth Bader Ginsburg's life, not her death and the concern with what the rule of law will be from here on out, but just her death, her life as a call to action in the face of these problems. I'm thinking about Kimberly Crenshaw's observations that rights have been important. She says they may have legitimated racial inequality, but they've also been the means by which oppressed groups have secured both entry as formal equals into the dominant order and the survival of their movement in the face of private and state repression. It's the end of the quote. But I think the idea that the rule of law ideal can be challenged, right, for its masking of power, and also used to expand the promise and I guess the effectiveness of the law, that seems to me a lasting legacy of Ruth Bader Ginsburg, and one that we are challenged to pursue in the face of this frightful news from Kentucky. Thank you.
Thank you so much. So, you know, I do want to say, as we think about her legacy and really what's required right now, oftentimes as a law student at Howard University, one thing that I was fascinated by was the audacity of Charles Hamilton Houston and others during the 1940s to even dream of the fact that they could overturn the law of the land, like the audacity to believe it. And I think
they could use the law to overturn the law.
Exactly. And I think we find ourselves in a similar place where there is so much distrust, so many things that are wrong with the criminal legal system, so many injustices. But I think we're called upon right now to look at specifically how can we use the tools in our toolbox to actually create new laws and to actually, because I'm not a big fan of precedent, you know, I'm a fan of resist, and how do you actually use the law to actually serve those who are most vulnerable in our society. So Professor Davis, we have a question from the audience for you. from a recent law graduate, a Black woman who has chosen a career in prosecution. And she wants to know exactly what can she do, what actions can she take. Can you please offer any wisdom for a Black woman graduating from law school who's pursuing a career in prosecution?
Yeah, thank you so much for that question. You know, when I was talking earlier, I was saying that action needs to be taken, and I was talking about the power of prosecutors. You know, as a baby prosecutor joining a prosecutor's office, you only have the power that the chief prosecutor of that office will give you, and what you're able to do depends on who that chief prosecutor is. And most of what goes on in our criminal justice system happens on the state and local level. There are federal prosecutors, but there are only about 10% of criminal cases are in the federal system. I'm not saying that's insignificant, but 90% of what happens in the criminal justice system happens on the state and local level. And in all but 5 jurisdictions, the local prosecutors, and they're called district attorneys, state's attorneys, commonwealth's attorneys, they're elected on by county, by city, etc. There are about 3,000 of them out there. And they are elected officials who get elected every 4 years, sometimes 6, but usually every 4 years. And people just don't pay attention to district attorney races when these folks are the most powerful officials in our criminal legal system. And so people need to pay attention to district attorney races, because who that district attorney is key to what happens in the system. And I'm happy to say that in recent years, the last, I would say about 5 or so years, there's a small growing movement of what people call progressive prosecutors, people who are running for office, challenging the incumbents, some who've sat for decades, and they're running on a platform of ending mass incarceration and ending racial injustice and ending racial disparities and holding police officers accountable and creating wrongful conviction units to free wrongfully convicted people. And some of them are doing it. So what I would say to this student, if they're lucky enough to join one of those offices, there is a lot they can do, because in those offices, and I'm talking about offices, I'm talking about people like Kim Fox in Cook County, Kim Gardner in St. Louis, Larry Krasner in Philadelphia, Chesa Boudin in San Francisco, who's probably one of them, doing probably more than most. Scott Colomb in Mississippi. They're all over, and they are out there making change as best they can in their community. So I would say to this student, if they are fortunate enough to work for one of the progressive prosecutors, they will be able to make change, because these prosecutors are, and they're not all the same. Some are doing more than others, and this is a political job. And so Scott Colomb, who I admire greatly, is in Columbus, Mississippi. He's not going to be able to do the same things that Larry Krasner can do in Philly and Chesa can do in San Francisco, because he's in Mississippi, but he is pushing and doing as much as he can to bring fairness. So I for one, hope that movement will grow of prosecutors who are willing to use their power and discretion to free Black and brown people from this system, and to hold cops accountable when they need to be held accountable when they break the law. And we need to have more of them, and we need people to pay attention to these races, and we need people to run. We need somebody to run in Louisville, Kentucky against the incumbent the next time he's up. We need somebody to run in Shelby County, Kelly, against the horrible district attorney. I'll say it. I know this is the ABA, but she's horrible. She's awful. Don't get me started. I'll stop. I could go on and on.
No,
sorry.
As someone who is my hometown, Shelby County, yes, the role of elections and the role of the community and making sure that the people, specifically the district attorney, holds your values is a very important part of the change that we need to see in the criminal legal system. So we have one question around language that came through, and I'll invite my panelists to weigh in. Someone asked a question about the use of the word criminal legal system versus the criminal justice system. So I want to be very clear that I don't use the term criminal justice system because of what happened today with Breonna Taylor's case and the non-indictments of the police officers who killed her. There is not a lot of justice, specifically for me as a former public defender, for the clients that I represent, but in general, for me as a Black woman, my community, we oftentimes do not receive justice. So I think it's more appropriate to name it what it is, which is the criminal legal system. So happy if anybody else wants to weigh in on the language.
Same. Yeah, I ditto everything you said, April. I'm retraining myself now. I've written, for decades about these issues where I use the term criminal justice system, and now I don't use it anymore. I slip every now and then, but I'm reminded every day, and especially today, that it's a criminal legal system. It's not a criminal justice system for me, for people who look like me.
Exactly. And it's tricky because we're the criminal justice section, which I can find a reason to somewhat hang on to that term.
So you have to say it.
So it's ideal to be a section that aims for criminal justice, but the system we have right now.
It's aspirational.
It's a very aspirational term. Kelly, you got anything to add around the use of those terms?
I just wholeheartedly agree with everything that you both said. And I'm embarrassed that I've used the phrase criminal justice system because it really is the criminal legal system. I agree.
All right. Well, we are getting a lot of questions from our audience. Another person specifically wants to hear about the vanishing trials in federal court. Professor Davis, you commented on the fact that between 90 to 95% of the people who come into contact with the system, cases are resolved by plea bargaining, not through trials. And how does that impact communities of color?
So, well, I'm sorry, the question was precisely what again?
Can you comment on the vanishing trials in federal courts?
Yeah, in federal courts, I would say people who watch, Law and Order and all of its many iterations think that there's all these trials going on. There are not a lot of trials going on. There are a lot of guilty pleas going on. 95% is generous. In some jurisdictions, 97 to 98% of all cases are resolved by way of a guilty plea. And the process is not a fair process. I'm not saying that people shouldn't plead guilty, but the way the plea bargaining happens in the United States of America is a tragedy. It bears no resemblance to justice. There are jurisdictions where individuals on the same day they are charged, the prosecutor will come to the defense attorney and say, your guy's charged with a felony. He's charged with 2 felonies. He can plead guilty to 1, or he can plead guilty to a misdemeanor, whatever he's offering, but he's got to take it today. And if he doesn't take it today, it's off the table. Or they put a timetable on it. And the defense attorney might say, wait a minute, I have an ethical obligation to investigate the case against my client to present the best defense possible. So can I get discovery? Can I get, have time to investigate? And the prosecutor will say, take it or leave it today. Take it today or it's off the table. And that is what passes as justice in the United States of America. That's actually not illegal or unethical under the model rules of professional responsibility. It should be, but it's not. And so the process is an unfair process. You find people who are facing, and because it's so easy to charge, right? Like what's happening with these cops, it's actually really easy for prosecutors to bring charges. The standard is probable cause, more probable than not, right? Much lower than the proof beyond a reasonable doubt that they need to convict. But that allows them to overcharge, to pile on charges that they know they can't prove beyond a reasonable doubt, to pressure people into pleading guilty, because anybody's facing 5, 6, 7, possibly mandatory minimums, facing 10, 15, 20, 50 years. If they're offered a plea that's going to guarantee that they're not going to get that time, even an innocent person will take that plea, and many of them do. So it's plea bargaining. I'm not saying that it's wrong to have plea bargaining, but the way that it is done in this criminal legal system is unfair and unjust and should be unethical, but it's not. And so that's the problem that I have with our plea bargaining system, is the way that it is done.
And Professor Steinhardt had a comment.
Yeah, I just want to add on to something that Professor Davis was just talking about, and that is in my day job, I'm an international human rights attorney, and it brings me into contact with a lot of foreign attorneys who are fighting a variety of human rights abuses on many fronts in many countries. And there are a few things about American legal culture that are impossible to explain, even to people of goodwill, people who don't hate Americans at all, and actually respect the ideals on which the United States purports to live. One of them is the death penalty, which is almost unheard of in other countries. Why we would have a kind of death culture like that is inexplicable to people of goodwill. Our gun fixation is almost impossible to explain to people in other countries. But plea bargaining is right up there with being a kind of unethical, gun to the head approach to guilt or innocence. And it is simply inexplicable to lawyers committed to the due process of law and the fair application of the law, that this would be so characteristic of the American criminal legal system.
Great. I totally agree. I think from an international standpoint, when people, and again, whether or not you have actually gone into your local courthouse and do you really truly understand how the system operates? I think similar to people's awakening around the use of force by police in killing Black men through George Floyd's killing, I think there will be a similar awakening if you would sit for one day in your local courthouse and see exactly how, quote, justice is served. We have another question from Facebook. Professor Davis, how do you get information on your DA race and who's running for office?
So on your particular DA race, so I'm gonna say that there are two sources, because I'm trying to think of sources that have information about all the DA races, right? The ACLU and Color of Change both have educational programs at their websites about district attorney races across the country. I think the ACLU program is called Know Your DA or something like that. If you just go to those websites, they will give you a lot of information about district attorney races and about how to find information about your local DA race, when it's happening, who's running, etc. And there are a lot of active races going on around the country now, and things are changing. Historically, DAs would run unopposed. Some of them would run for decades because they didn't talk about what they would run on an I'm tough on crime platform. If anybody challenged them and rallied with they'd say I'm tougher on crime. Nobody talked about plea bargaining. Nobody talked about the issues we've been talking about, charging or anything. That is changing now. And it's only going to continue to change if people press. And so people have to get involved in these races. There are forums. Tonight, there's a forum in New Orleans on Zoom of the people running for district attorney in New Orleans. And so there are active races. There's an active race in Los Angeles now happening all over the country. But I would say go to the ACLU website and also to Color of Change, and both of them should be able to provide information about how to find out specifically about your DA.
Okay, great. And Kelly, we actually have a question from you from the audience. What else can we do for Purvis Payne besides sign petitions and raise awareness on social media? Are there any numbers? Can we call public officials? And specifically, how can I, as an undergraduate student, get more involved in public defense work from the attendee?
Well, thank you for that question. Besides spreading the word on social media, signing up on our petition, also speaking out at Zoom meetings of any organization that you might be a member of, talking to your neighbors. We have issued challenges to folks to say, talk to 5 people who don't know about Purvis Payne, tell them about his case. also writing letters to Governor Lee. We will be requesting clemency from Governor Lee at the beginning of October will be when we present our petition. And as many letters of support as we can get, the better, because the governor needs to understand that it's the will of the people to commute Purvis's sentence. As a law student, that was the way I got involved in public defense. Is I had a mentor in law school who was a public defender, and he got me hooked on doing death penalty work. So I would say, reach out to your local public defender's office in whatever jurisdiction you live and ask for internships. They don't pay. Sometimes your school will give you externship credit. We've done that in my office. I'm at the Federal Public Defender in Nashville. We've had externs. We've had summer interns. We are doing virtual internships. There's also a new organization called the National Habeas Institute, which was started by a colleague of mine named Robin Conrad, where she is helping students of color become trained in doing the type of work that I do, so that there's a pathway, a career pathway for those students once they graduate. So that's a great question, and thank you for asking it. And I just want to answer also the previous question about finding out about your local district attorney, and that is to check with the National Bar Association chapter in your particular state. I know that the Ben F. Jones chapter in Shelby County, Memphis, Tennessee, is very active in keeping tabs on the local DA and the upcoming election in 2022. So the National Bar Association can also be a great place to look.
And can I also just very quickly add, April, we haven't talked about public defenders enough. Please support the funding of your local public defenders, because without a strong public defender to hold prosecutors accountable and to hold judges accountable, we're not going to have justice. And I want to give a shout out to the National Black Public Defender Association, and also to Gideon's Promises, two organizations that are really fighting to strengthen public defenders. And also, if there's anybody out there who themselves is interested in challenging an incumbent district attorney who is not doing justice, please contact me directly. Or if you know of someone who wants to run for district attorney, please contact me, send me an email, and let's talk. I'll help with that.
Wonderful. So actually, Angela, your comment kind of leads us. I'm going to wrap up. I'm really excited because we have a very active audience and we're not able to get to all of the questions. But this last question, I think, will allow our panelists to suggest action items or what you see as solutions. The question is, where do you see the largest needs or resource gaps to address the issues you highlighted today about the criminal legal system? So I will echo what Angela just said, that the role of public defenders, the reality is 80% of people who have contact with the system are represented by a public defender. And it may look different in a lot of places. It may be a court-appointed attorney, it may be a larger office, but the role that public defenders play, and I've oftentimes referred to my job at PDS as working in an emergency room. You triage. We try our best to stop the harm and the damage that is being done to our clients, but only officers who have adequate resources and training, and also connection to community. Public defenders cannot do this work alone. You have to be connected to community. There's a challenge to practice that we see today. So that's my response to your question. I think the role of public defenders, but also the role of public defenders in dismantling the system. My goal is that the Black Public Defender Association, we will work ourselves out of a job. We want to transfer power and resources back to the communities that need them, and to see our community be treated differently and be offered solutions that are available to other communities, so you don't have to call the police to resolve issues, that you have the resources and hours to law enforcement. Conversation around dismantling versus reforming is a very much conversation right now. We talk about resources, fund, defense. We should also think critically about all of them. We're trying to reform them. So it's pretty poor. It's not protect us. Um, you first. On my end, and I have issues. So, Ralph, for you all to answer the questions, close this out.
I agree. I had a hard time hearing a lot of what you said, April, but what I did hear, I totally agree with. We need to fund and support public defenders. We need to work to not reform, but transform the prosecution function and transform the police function entirely in this system. And that's by people getting out, holding these folks accountable. The prosecutors run for office, ask them questions, run for office yourself. Police officers don't run for office, but they are appointed by mayors in most jurisdictions, and the mayors are elected officials. So become active in that way, and we can help to transform this system if we do that.
Kelly, you're muted.
I would also add that it's important for us to educate ourselves on this issue of implicit bias. We need to read, we need to attend these webinars that are being shown to us right now. I know that many of us are cooped up in our homes because of COVID. This is an excellent time to take advantage of some of the excellent online training resources. I know the ABA offers many. We need to educate ourselves so that we can overcome the biases that we have. And I also just want to echo how important it is to support your local public defenders, because public defenders are often treated like garbage in court. And we feel it every day, and it's easy to burn out as a public defender. It's rare for somebody to stay in the job as long as some of us have stayed in the job, because we just get tired of getting beaten down. So those of you who have the opportunity to lift up your public defenders, please do so and support them, because they're doing, the work of the Sixth Amendment.
I think I would just add to these brilliant suggestions. At some point, it's not just using the legal system to dismantle racism. At some point, it's making broader social changes of which the law is a part. And for that, I guess I want to return to something that Kelly talked about earlier, and that is well-meaning liberal white people, where it seems to me well-meaning liberal white people exactly have to become aware of the ways that their silence and their standing by perpetuates a system that they would not endorse, that they reject in their hearts, and yet do little to actually alter. So that's my action item, in addition to the cases and the kind of things that the other panelists and the audience members have thought of. I think that there's an individual commitment at each level to try to hear the voices that aren't heard.
Absolutely. So Ralph, thank you so much, because I think it reminds us that we all have a personal obligation to examine issues of race and equality, and how, whether consciously or subconsciously, there is something in our society and within the framework of the legal system that has allowed these ordinary injustices to exist for so long. So join the fight. I'll announce on the rule of information. Thank you for joining us.